So we have a very tight time frame because we have very busy ladies here. So I'm going to start right away. So thanks everybody for joining us today. Hopefully that you will come away with lots of great ideas and have learned quite a bit because both these ladies are very accomplished. Leanne is a senior lawyer and she is part of the Benmor family law group, but she's topped off her credentials, Bachelor of Arts in Education from the University of Toronto with a Juris Doctor from Western. And she's worked over 16 years with being an assistant Crown attorney in the domestic violence co-lead, and then created a law office that was Townsend Family before she joined the Benmor Family Law Group. And so she's been working in this area for quite some time. And then Samantha Graff, who comes from the real estate world, followed in her mother's footsteps and is co-founder of the Graff Realtor Group. And she's a seasoned realtor, has 3 decades of working in this area, as well as a mediation certificate from Harvard. And she's helped countless families find homes. So we're going to pose a number of questions to them today, and throughout, if you need to ask questions, feel free to jump in. But for the most part, I've gathered some ideas as to what I think are really important for us to learn about. So thank you both, Samantha and Leanne, for joining us today.
Thanks for having us.
Great. So Leanne, I'm going to start with you and ask, if the money is coming from parents for a down payment, how is that looked at? Is it considered a gift? Is it advance on inheritance? Is it a loan? How does that look like?
Well, I'm going to give a typical lawyer answer to that question, which is it depends. Here in 2025, this is a scenario we see, more and more with the price of housing. Particularly I live in Toronto, the GTA, over the last, 10 to 20 years. Real estate costs have grown and grown, and so it's become much more common for parents to help their children purchase their first home or maybe even subsequent homes. That's something Samantha will be able to speak to more, but certainly it's a much more common phenomena. And how that money is classified will depend on a number of things. And it's very important that the evidence supports what the intention is uh, of the person who is giving the money. Because down the road, should the child end up getting a divorce, how the money is classified will, how it will be treated in the divorce, it will have significant consequences. So you mentioned, Linda, is it a gift? Is it a loan? And then a third option would be an advance on an inheritance. And so whether it's a gift or a loan or advance on inheritance will depend on the intention of the person who's providing the money, but it's also going to depend on the evidence that supports it. And if there isn't really any evidence supporting anything, that the presumption is that it's a gift. So if parents give money, if money's provided, there's no loan documentation, there's no documentation period. The presumption is that it's a gift. And if it's a gift towards a matrimonial home, the presumption is going to be that it's a gift to both parties, not just to the child of the person providing the gift. It would be assumed it's a gift to both parties. And then also because it's going into a matrimonial home, matrimonial homes have special status under the law here in Ontario. So gift is the general presumption. Now, if the parents mean it to be a loan, then they're best to have loan documentation that is set up at the time that the money is provided. So they want to have, a loan with a payment schedule, or perhaps it says that, payments aren't due or they're due on demand, or, an interest is not payable or, whatever terms they want to put. But if they want to be able to call it a loan, like they may want to call it a loan for two reasons. One is they actually want the money back. They want their child and the child's spouse to pay it back. But the other reason could be because they want to protect it should down the road there be a divorce. Because if it's a loan, and the parties later divorce, then that money is going to be paid back to the parents before there's any sort of equalization of net family property. That money's going to be removed from that equation. Whereas if it's a gift, it's just going to be included, and both spouses are going to get a portion of it. And there's a lot of cases, a lot of court cases where people are arguing about whether money from parents was a loan or was a gift. And as I said, you're going to look to the evidence surrounding it to determine which it is. And I see that Carl has a question or has a comment.
Go ahead, Carl.
So my question to you is, because Leanne, you're in law, in real estate law. So from
I'm
a
in
lender
family law.
perspective, oh, sorry. So from a lender perspective, like when you're getting a mortgage for a house and there's money being transferred from a parent to a child for the purpose of a down payment, that has to be obviously attributed because again, they're looking at a 90-day history of a bank statement. And if they say I see $200,000 dropped into the kid's bank account, well, then the question is, okay, where'd that money come from? And then if it's a gift, there has to be an actual gift letter. So my question to you then is, well, what happens if a parent does that? Because if it's not a gift and they say it's a loan, then that loan gets attributed to the qualification of a mortgage. So most parents are going to say gift, so it allows them to do that. But if in the background they suddenly said, no, really it was a loan, which document becomes, real in essence when it comes down to a situation of a family dispute?
Well, when there's a dispute, you're going to look at all of the evidence. So, I mean, and if there's conflicting evidence, that's a problem. So if there's a gift letter and there's loan documentation, you have a problem. And you're going to have to look to, people are going to be cross-examined and questioned on the circumstances surrounding it. Maybe there's emails that were exchanged, there's letters, whatever it might be. You're going to have to look at the whole picture to see which is supported. And like in my experience, gift letters are somewhat uncommon. A lot of parents, when they're giving money to their children, they don't think to, have a gift letter indicating this is a gift. And there's actually then no documentation. And so you have the presumption that it is a gift.
Oh, no. Like if there's money being given as a down payment, lenders want to see where that money came from.
Right.
So there has to be a gift letter. So if it's anything over, I think right now it's anything over 10 grand or something like that, they're looking for documentation to verify. And it can nowadays with the way things are going, like we're talking like $200,000 are being gifted for,
Right.
this generation to be able to even afford a house, never mind the mortgage payments. So in that case, there is, the lenders are again protecting themselves as well from risk mitigation standpoint. Where's this money coming from? And it also falls underneath that umbrella of the anti-money laundering system of, okay, where did this money come from? So if there's like 200,000 being dropped into someone's account, you have to show where it's come from. So if it's coming from mom and pops, there is an actual gift letter that has to be signed.
Right. Well, and then that goes towards it being a gift. But again, if you have conflicting documents,
So
you're
my
going to have to
question
look
is,
at all of the evidence,
yeah.
and whatever is the most credible is going to be, if it's in front of a judge and the judge has to decide on it, it's going to be whatever the most credible evidence supports.
So what are you finding though that's happened? Like,
Again, it really goes all over the place. It goes all over the map, depending on what the evidence is. These cases are very fact specific in terms of what evidence there is. I haven't seen a lot of gift letters. Now, you're saying there's a lot of them out there. In my practice with cases that I've dealt with where this has been an issue, there hasn't been gift letters, and often there's no documentation. Sometimes there might be some sort of promissory note that's not done properly. It's just the parents signing something saying I loaned, Junior $50,000. But it's not witnessed. It wasn't done by a lawyer. There's no payment schedule, and it's not dated. So, it could be questioned whether that was just drawn up when it became known that the parties were going to separate and divorce. And so they wanted to then decide it was a loan. I've seen lots of things like that. But in each case, it's really very fact specific, and you're going to have to look at all of the facts and see what the evidence supports, and it can go in many directions depending on what that evidence is.
Sorry, quick question, Susan here. Could you leave, so, this is probably going to happen to me soon with my family, with my girls. And so if you gave them, let's say 200,000, because that's what Carl's using, 200,000, could you say no interest paid, but interest will be owed if the home is sold or separation? Well, I guess sold would be separation, right? Could you do that?
Yeah,
So
we
that
could do
way
that.
it's not onerous on the kids. I don't know how the bank would look at it, but it's basically I'll get the money back if they sell.
Yeah, and I can't speak to how the bank would look at it because I'm not in the bank. But from a family law perspective, if you can certainly do that, and that type of documentation would offer a protection that the money is a loan.
Okay, thank you.
We also have a question from Debbie Patton. So if an advance on inheritance is the amount excluded from equalization on the divorce, is a portion of the growth of the house attributed to the inheritance and excluded from the equalization?
No, like if money that goes into a matrimonial home is not a regular type of inheritance or advance on inheritance. So if a parent loaned a child, or sorry, if a parent gave a child money as an advance on an inheritance and it went into not a matrimonial home, so say an investment property or something like that, and it was kept, it wasn't commingled with joint assets, it was something separate, then that would be excluded from the equalization. But if it goes into a matrimonial home, then it's commingled essentially because matrimonial homes have special status under the Family Law Act, and so the exclusion would be lost in that situation.
Okay, great. So we're going to ask Samantha to weigh in on some things. So when you're encountering couples that are separating and they're looking, now we've got to figure out maybe two new homes and that sort of thing. What are you finding are the biggest challenges, and how are you finding that people with their parents are getting involved?
So I think that there's sort of two ways to consider this situation. It's there and where they're functioning from. One is from the emotional and one is from the practical. So the biggest challenge is there's a lot of uncertainty that is surrounding their situation. So trying to get clarity on that is probably one of the biggest challenges that I encounter personally. So I try to find out whether that's, working with their lawyer like Leanne, or whoever, or the parents that are involved, like how clear can we get on their situation? And I think that things like accepting this new life stage is another challenge that I do face with the clients and even with the parents involved. I mean, we've been talking here about how it's pretty much close to, I mean, the percentage of people who are buying homes on their own without their parents' help at this point is quite small in Toronto. And, I'm not only getting it from separating clients, I'm obviously getting at it with first-time buyers just trying to get into it. And then on another level, and I think, Linda, you and I talked about this at some point over the last couple of months, that I've had situations where my clients are trying to go from like the dollhouse, into the 4-bedroom newer home. And there's such a difference in price. Like we're talking, maybe 1.8, and then they're jumping to 3.5 or more. And parents are getting involved in those situations too. So it's similar. But with the specific situation of separation, I think the uncertainty is the hardest challenge.
So when you say about getting clarity, like how do you go about that? What kind of questions are you posing to them?
So, I mean, first, I try to get them to be sure that they've spoken to professionals. Leanne, obviously being one, the mortgage broker, financial planner, getting as clear as possible on those numbers so that they're not fictitious. I think the paper trail of that. Now, something some people may or may not know about because it's relatively new. I don't know the exact date, but when you're going through a separation or divorce, and you go to your mortgage broker, there is a new allowance for those who have they say they need proof of marital breakdown, which is typically a separation agreement or a divorce settlement agreement. And they then are awarded basically first time buyer allowances. So I don't know, a lot of people don't know about this because it's very new. And I think they're still trying to work out the tweaks in it. But they are a little, what I would like to see them do, I don't love that they need a settlement agreement or a separation agreement because Leanne, you could speak to this a little bit more. But at what stage in the journey? I mean, people could be separated or divorced for years and they want to go buy a house. They could have sold the house even a year or two ago, and here they are sitting in limbo, renting, and they want to get back into the market. And that's another really big challenge, actually, is if they do not sell the matrimonial home and buy within the same year. I always tell people buy and sell in the same marketplace. And you could be trying to enter a marketplace that's gone up or, these days, not so good. It's down. So there's complications with that as well.
So when you mentioned about them being first-time home buyers, so part of what you're helping them understand is that they could use a first-time home savings account or their home buyer plan and that sort of thing, which I think is not well known.
Not at all. Not at all. Because it's very new, I think people are shying away from it. And they're not clear on it. And I actually think there should be a lot more education on it. And like I said, I would love to see the movement. Leanne, maybe you and I can get on that and figure out how to move it forward.
Yeah, absolutely. And on the note of Samantha was talking about separation agreements and the need for them. I've seen situations where I've been asked to draft sometimes like an interim document or just a letter even that specifies that, on such and such a date, these two parties separated, there are two children, and there's going to be this is it, the anticipated child support is such and such, and spousal support, and like kind of outlining some of those details where they don't actually have a final separation agreement yet, but there is sufficient information in the letter to satisfy the lender or the parties so that one or both of them could purchase a property before there's a final separation agreement or final settlement.
And that's where that part actually does help with one of the challenge, like I said, about uncertainty. And the people that can help with that are people like a Leanne, professionals like Leanne or the mortgage broker who can show qualifications or different things so that we can move forward in, the search.
Mm-hmm. So as far as putting somebody's name on title, Leanne, if it is parents getting involved, is there a benefit, or is that something that you're seeing that works to have like a parent or whoever's part of the funding put their name on the ownership of the property?
There can be benefits to it. I mean, as I'm sure everyone here knows, title determines ownership. So if a parent's name is on title, then that is giving them a form of ownership in the property, whether it's done as joint tenants or whether it's tenants in common. And it can be a way of protecting their investment in the property. So, even just as an example, I have a client right now, and her father has a 1%, tenant in common ownership in the matrimonial home. And he did give some money towards the home when it was purchased. And the parties are going through, separation and divorce now. And has been added as a party to the proceeding. So unfortunately for him, he's had to lawyer up and has to attend, the court appearances with the couple. But his involvement in it is just that he has this 1% ownership, and he wants to protect that so that he will get that money back. And if he didn't have that ownership, then we'd be looking again at, is it a gift? Is it a loan? What's the documentation? What does the evidence show? So it can be a benefit to have a parent on title. And I think we do see more of that now, just because sometimes they're going on just to help the couple qualify, to get a mortgage in the first place. And so it is something that I am seeing more of.
Then I have a question actually, Leanne, about that. Then if like because I sell the matrimonial home a fair amount, and I haven't had that experience yet where there was anybody on title other than one of the spouses. So if a parent is on title, technically I would also have to have them sign my listing agreement, sign off on the offer.
Yeah. Yeah. I mean, so it's a little more complicated because you've got an extra party, and, there can be issues of, put two of them ganging up against the other one. Like, there can be conflict that way because the parent is, obviously and their child are probably going to want to do similar things inside together. And so it can be more complex, certainly I would think in terms of selling it.
Sure. So based on what you're saying, it's a way for the parent to protect their money, but not without a cost to them if things, wind up with a separation happening.
Yeah, because as they say, then they potentially will have to be added as a party, and then they have to incur legal costs and things like that, which nobody usually likes to have to incur. So there is the downside to that. I mean, probably structuring it as a loan is a better option to protect their money, and just properly structure it as a loan from the get-go.
And
Mhm.
then on my side too, it will be more complicated with a third party on that title. So it doesn't sound like it's the best. I mean, there could be advantages. Look, every scenario, every house, every family is different, and you have to cater to their situation, no matter what industry you're in. That's service, right? And that's, getting the job done. It's personalized. There's no one size fits all
Mhm.
um, solution here.
For sure. It's helpful for us though, because sometimes people come with their own creative solutions, then they need to know the good, the bad, and the ugly. Like if you do this, this can protect that money, but here's, be prepared for these other situations to occur going
Options.
forward. Yeah.
And that's why it's really helpful, I think, for any parent who is planning on providing money towards a home, for them to get like legal advice from a family lawyer, when they do it, to figure out what is the best way of structuring it to protect the money, protect their child in some fashion if that's one of their goals. But it's certainly, I think, a good idea for them to get legal advice before, forwarding, especially if we're talking, like the number Carl was talking about, $200,000. That's a lot of money to most people.
Yeah, for sure. So Samantha, when you're finding that, parents are involved, that they've put their money up or they're willing to put their money up, how involved are they as far as going and finding the house and approving, whether this is the home that their child is going to purchase with their partner?
Just as we were talking, each scenario is 100% different. The level of engagement, I could have for lack of a better term, a helicopter mom or dad. And, they're right in there. It can be challenging. I personally have found my best way to navigate it is that I have typically, it also, I have to rewind because it does sort of also matter where that typical like referral comes from. I mean, Cheryl and I at this point in our career are about 90, I think our number is 94% referral. So sometimes we get referred to the child by the parent. Sometimes we get referred by the lawyer or a divorce coach, financial planner to the actual spouse that's separating, and then they bring their parents on. But my first meeting is with whoever reaches out to me, but I always say to them, if there are going to be parents involved, let's clarify that role. Let's have a group meeting first. And then I also just like when I deal with selling the matrimonial home, I never actually really have a conversation with both spouses in the same room. It's usually high conflict that I deal with. But I have had a few experiences, luckily, where it wasn't, and I did. But usually, basically, I have to do everything twice. It's like double the work. Uh, so I have to go through the process, and here it becomes like triple the work, right? If I have to actually involve a spouse too, somehow. But with the buying, that's usually not the case because they're separate. They're obviously not buying again together. Otherwise, I'm sending them back to Leanne for sure for a very good, tight marital contract. But some parents, it depends also, is there a mortgage broker involved? So then I sometimes have to have a meeting with the mortgage broker also. And that depends how much they want me involved in that portion of it. But I do end up referring some mortgage brokers who have a little more experience with this, or a financial planner who's been involved in this a little bit more. But at the end of the day, you just want a really strong mortgage broker who can give you, I mean, let's be real, it's really about the numbers a lot of the time. When it comes to the mortgage broker, there's a bit of strategy definitely involved. But I would say that, separating them and listening, hearing what each individual really wants from this, because the parents typically are really looking at a financial investment. And the spouse who's they're so grateful, first of all, usually for their parents' support, but they're also really worried about their kids. And then you have to, consider things like how far is the ex from there, what school district, like there's a lot of things that sort of come into play that, we have to be sure about. And I always just try to keep everybody calm. I just sold 2 properties actually in the last 2 weeks. And, in one case, one of the spouses was very wired about everything, and it wasn't necessary. And, just keeping that calm, like the minute she got on the phone with me, within 3 minutes, she came down like 10 notches. It's just keeping it all in perspective, and reframing it. I do a lot of reframing. That's a big one. So I think also just communication, that's a big part of it. Clarity. I've, in many cases, taken a child. We could be in, say they're going to a condo from a house, because that's the reality of it at this point. And the parents are all into this condo, and it's perfect for them, and it might not be for the spouse and their children, or just the spouse, and so I'll always be sure that they really are okay with it. It's not just to appease the parents, because at the end of the day, for me personally, I cannot sell somebody a property they're not excited about. It just doesn't work for me. I'd rather work harder, work longer, and we'll find that place. But I want, in this specific situations especially, they need to see it as their new home. Like they're new, it's their new life, and you want them to be excited about that.
For sure, for sure.
I was going to say, certainly too, in divorce sales, it's really important to have agents like Samantha that, have a lot of experience dealing with divorces, because there are different, nuances and considerations and challenges that come up in a divorce sale. And so, as professionals who refer business to other professionals. I think it's always important when you're looking at real estate agents to make sure that they do have divorce experience if your client is somebody who is going through a divorce.
Yeah, it's no different than they hire you, Leanne, and who is a divorce family law specialist. Like that's what you do. I mean, I'll tell you, when I first started in my career, it was it'll actually be 30 years this December 5th coming up. And in the beginning, I was taught also by my mother, but also by schooling, like farm a market, be the specialist in an area. And the last 8, 9 years, I mean, even more than that, we've been all over because we're referral, but specifically in relation to separation and divorce. And I've done a lot of estate sales, and I've also seemed to sort of be involved in that place where you go from a home to a condo, which is a very um, it, it's challenging for a lot of my clients. I mean, I'm just waiting now. The market's gone down again, and we're not sure. We're sort of feeling a little challenged because this was the fall after about honestly 8 to 10 years. I've been working with this woman trying to get her through out of the house into the condo, and it sort of plays with your brain because of your age. You're in your late 70s or 80, and you've always lived in a house, and it's like, this is going to be my last step. So similarly with separation and divorce, it's this new life stage that is uncomfortable. And you want somebody who's patient. And a lot of realtors out there are not patient. It's like a known thing. My broker says it, like the ones that are really going to be successful are patient. And Leanne definitely can speak about this through the process of separation and divorce. Because when I say I've worked with a client for 8, 10 years, I mean Leanne and has worked with clients the same amount of time. Like, think about that. Like, you just want some stability, you know? So it,
Sadly, some separations and divorces go on that many years, which is surprising to many people.
Yeah, it sure certainly is. So, Leanne, when there is this, parents or grandparents' money that has assisted with the family, and whether they've, gone to the right people and done everything they should or not, how does this play out when then people are dealing with the equalization and the net family property, which I mean, my experience has been a lot of the clients don't even understand the net family property statement. So then this adds a whole nother element.
Yeah, so the matrimonial home, as I touched upon a little bit earlier, has special status under Ontario's Family Law Act, meaning that unless there's a marriage contract, the full value of the matrimonial home is equalized. It doesn't matter whose name title is in. And if a parent has, given a gift of money towards the matrimonial home, or if a party inherited money from a parent and they put it towards the matrimonial home, the money will, be equalized as the matrimonial home is equalized. There's no exclusion for it in that circumstance unless there's a marriage contract. And it's different if it's not a matrimonial home. If you have an inheritance and you put it into a property and you keep it separate and it's not commingled with joint money, then it would be excluded from the equalization process. But the marital home has that special status. So, and this is something that, we see a lot because the matrimonial home is generally most people's largest asset or their most expensive asset. And so they inherit money and, oh, like, let's go buy a new home levy. And they put, money from that inheritance into a matrimonial home, and they lose that exclusion. And so that's why, again, it's really important for people to have things like marriage contracts or prenuptial agreements or cohabitation agreements and these sorts of things, because then you can protect that money, even if you're putting it into the matrimonial home that has that special status.
For sure, for sure. And you touched on if it's a second property. So if it's a second property and it's like the cottage or something that the family uses a lot, but it's actually money came from a parent and then it stays in the child's name, does that still protect it? Or does
Sorry, Finn, it's interesting that you mentioned cottage, because a lot of cottages are often considered to be matrimonial homes. So the definition of a matrimonial home is a home ordinarily occupied by the parties on the date of separation. And you can have more than one matrimonial home. So if you have a cottage that you're going to regularly as a family, you're spending summers there, you go there weekends, whether you use it throughout the year, if it's winterized or whether it's just seasonal, if it's a property that the parties are, both regularly going to, then the cottage would likely be considered a matrimonial home in those circumstances. So similarly to the primary residence that's the matrimonial home, any money that's gifted or inherited that goes into a cottage is going to be equalized. It's not going to be protected. Parties are not going to get an exclusion from their net family property for that. If it's another sort of property, like a rental property that, you have a tenant and you're renting it out, or if it's a cottage, but for some reason it doesn't meet the definition of the matrimonial home, maybe one of the party who's who purchased it just only goes there and the family never went there and the couple never went there. That's not a very common scenario, but if it was a situation like that, then you could get the exclusion for the money from the gift or inheritance that went into it. But generally cottages end up being matrimonial properties.
And same with, from my experience, also in what we call second homes anywhere around the world, typically for Toronto people, like Florida, for example, being a common one, that can actually be considered a matrimonial home, especially when you get into those like gray divorces, as they say, because there's a lot of them. They are here for the minimum amount that allows the health coverage, basically, and then they go to Florida. And I have a lot of clients in that situation. And if they went their separate ways, it would 100% probably be considered a matrimonial home.
Yeah, absolutely. And it can get complicated when people do have properties all over the world, because then you're dealing with jurisdictional issues and laws in different countries. And it can be harder, if you get a court order in Ontario and the couple has a property in Italy, there could be challenges with having that order enforced in Italy. And certainly there's going to be more costs because you're going to have lawyers in Italy helping with the situation as well. And so again, I think anyone who's in a situation where they can afford to have multiple properties, around the world, those types of people should definitely get, have a good estate plan and consult with estate planning lawyers when setting everything up to make sure that, in the event of divorce, things will unfold the way that they want them to.
Or have a post-op, post-op?
Post-nup.
Post-nup, that's
Yeah,
what I was looking
yeah.
for.
Yeah, you can get a marriage contract at any point in time. A
Updated.
lot of people think that you have to get them when you're getting married. And I mean, the challenge is like I had a client who was married for 25 years and his wife inherited a bunch of money, including an expensive multi-million-dollar property in Vancouver. And she then presented him with a marriage contract because she was concerned that she wanted to use the Vancouver property as a couple. But as soon as she did that, she knew it would become considered a matrimonial home and it would lose the inheritance protection. So she presented him with a marriage contract that she wanted him to sign. And he was like, no, we've been married 25 years. I'm not signing it. What are you going to do? And so she's in a difficult situation because basically she doesn't let him go to the home in Vancouver because she doesn't want it to turn into a matrimonial home. So as long as she keeps everything separate, it's protected. But so she's, unfortunately for both of them, because then he can't go there either, but he's just refusing to sign the marriage contract. But I have seen people sign marriage contracts, many years into their marriage. It is possible to have that done. You're not barred from it just because you didn't do it at the beginning.
You touched on the fact that it could also be a rental property. So if it's a rental property, but it's in one person's name and the rental income is being used by the family, does that change things?
No, so say you received an inheritance and you put it into a rental property in your name and you kept it separate, that rental property would be an exclusion from your net family property when you're doing equalization. The income from the property, however, is relevant to your income. And so, for support purposes and whatnot, the income could be relevant. And just on a different note, if you had a rental property that you inherited prior to the marriage and you brought that into the marriage, the growth on the value of the rental property would be something that's equalized. But the value of the rental property on the date of marriage would be something you would get an exclusion for.
So even though a rental property would stay in your name, because you brought it in, the growth would still get equalized.
Yes.
Okay,
Yes.
that's
Again,
really
have a marriage contract. That's the way to deal with these things. And they're becoming more and more common. Like once upon a time, marriage contracts for the rich and the elite, and they're much, much, much more common now. And I'm a big proponent of them. I think that everyone really should have one because it also forces people to have those difficult money conversations that a lot of couples, they're madly in love and they can talk about all kinds of things, but they don't want to talk about money. And it's really important that people be on the same page and it doesn't have the same taboo that it had once upon a time either.
I think another reason why it's also important from what I'm seeing now is because the affordability is so challenging these days. People are buying properties not married and in groups. So you're going to have a really complicated situation if like two couples or or just a bunch of friends together. This has been happening. People are buying. One of my properties, I didn't end up selling it to those people, but there was a situation and it was very complicated. And I felt like saying to them, you guys really need to talk to a family lawyer right now because it was like, they were new to the country. They've been here for a year and they had bought in a group and they bought a group investment that they were all living in this house, like a few families. And then they were going to try to buy this one. So they had to bring a different name in on because they wouldn't have qualified. Like it was very complicated. And I think that if any of those people are married and they actually ended up in separation or divorce, there's going to be so many people involved there, and it is going to be really complicated and cost a lot like everyone's going to be hiring lawyers, and you could just avoid that, with a simple marriage contract. I know people find them really uncomfortable and negative, but the way I look at it personally, and I mean, I'm not trying to say I got married much later in life. I'm 52 years old. I didn't get married till I was 46 for the first time. I clearly had invested in real estate, and you want to protect yourself, and it was uncomfortable, but in the same boat, I remember talking to my husband about a will. It's like, it's the same thing. Nobody wants to talk about it. Nobody wants to see that happen, but you just do it. And like, I don't even know where it is right now. But it's somewhere, and
But the lawyer's office
lawyers
for
have it.
sure.
But yeah, Yeah, but like, the wills and the marriage are sort of like they're out of sight, out of mind, and it can get heated. I mean, Leanne, you can definitely speak to it because we've had these conversations before. And, unfortunately, people like Leanne and other family lawyers have to, navigate not only the marriage contract, but they might have to advise or show options of where this could go in the future. And sometimes you recognize that these two people probably shouldn't be getting married. And like Leanne sees this enough to know that this couple is going to be in her office, or at least one side of them is going to be there, you know? But I think they're really, really important in today's day and age.
Yeah, way better to do it then. Patricia has a question.
I have a question regarding post-nups, and I agree with both of you about the stigma around prenups, right? So I'm wondering if we're likely going to see more post-nups. And the reason I'm asking is recently I was approached by someone who was getting ready to seek a divorce from her husband, and he had approached her before she approached him about the separation that she wanted, and he was wanting to get her to sign a postnup. And the reason for that is because they were in a common law relationship, and she moved into his home that he owned, so it now became the matrimonial home, and so he wanted her to sign a postnup. So I'm wondering, well, maybe we'll be seeing more of this.
Now, in this situation, were they married or were they common law still? Because the rights
They're married.
common law are very different than if they're married.
Yeah, no, they're married now, but they were living together in his home, and then they got married, so it became the matrimonial home.
Right. Yeah.
Right? So he was wanted her to sign a postnup, right? And so I'm thinking, I imagine we'll be seeing more of this where people are wanting to have postnups or have postnups. I'm just wondering.
Yeah, I think we will because even prenups are more common, or marriage contracts are more common. And so I think we will see more of that. The only catch is like once you're married, you don't have the same, like, what are you going to do if they don't sign? Are you going to get a divorce? Like that's the challenge with it. And As some of you or all of you may know as well, that, when you're dealing with any kind of cohabitation agreement or marriage contract or, prenup, if you want to call it that, if you have a pending wedding, like if your wedding is a month away and you decide at that point to go see the lawyers about getting a marriage contract, there's potential that there could be considered to be duress and things like that in that type of situation because of the wedding being so soon. So often lawyers will have clients in that situation sign something called a standstill agreement, which basically sort of puts a plug in the property ownership, the way things are before marriage stands still for a period of 3 to 6 months, depending on how the standstill agreement is drafted, until the parties can finalize the terms of the marriage contract.
Yeah, so I was wondering, is there anything that we should be aware of or look for if we are in that situation where we're working with spouses and there is a postnup? Is there a difference or something that we should be aware of when we're faced with that with our clients?
The only thing that comes to mind for me is you want to be careful that there isn't some sort of deceit or something going on, that the party who's presenting the postnup wants to get their spouse to sign it because they plan to leave them in 2 months, and so they're kind of almost wanting to negotiate while that party still thinks the marriage is going forward. And that type of situation I could see being problematic, because it's based on some deception and things like that. Otherwise, I mean, I would definitely recommend to people that they get their affairs in order before they get married so that it is a marriage contract from the outset and they're not in a situation, a year in, 5 years in, whatever, where they're trying to then negotiate with their spouse and their spouse says, well, sorry, I'm not signing it. And like, what are you going to do? You really have no negotiating power. At that point. So it's definitely better to do it at the beginning, but you can, if you didn't, it can be corrected and fixed, and there's no reason why you can't sign one at any point in time in the marriage.
However, wouldn't it be possible? You're talking about a standstill agreement, like when you are getting married, would there not be something equivalent for a postnup, like a certain time frame that if the person did leave, or would that just be part of, argument in court with a judge making a decision on that?
You mean like if somebody got their spouse to sign one and then they left?
Yeah, like somebody asks for a post-nap and like within 3 months they leave. I mean, there are people out there. I personally have a very communicative relationship with my husband, so I can't imagine that I would ever be blindsided, but it does happen. And somebody could sign it thinking like nothing's wrong in a marriage, but they're usually you kind of have an idea, I would think, but I haven't experienced it yet. What do I know? But I would think that there would have to be some type of allowance if somebody left that quickly.
Yeah, I think that that would certainly be an argument that a lawyer would want to make that they were induced into signing something under false pretense, and therefore it's not a valid contract.
And now, when being that the market is down, especially with condos, like it's the best time. I'm not suggesting to buy a new condo, by the way, but a resale condo, I would definitely tell people to buy right now. And as a family, could, if people have the money and they are accumulating condos right now, this is a time when you would want to, tell your clients that you're buying property, it'd be a really good idea to decide right now, post-nup, is it yours? Is it theirs? Is it 50-50? Like just build it into your portfolio as it grows. Have this documentation always.
Yeah, absolutely. And is just as a statistic, I think that I found interesting when I was preparing for today, I saw that 30% of first-time buyers in Ontario receive parental help for their purchase. So the types of situations we're spending time talking about today are, obviously pretty common if it's happening in 30% of the cases for first-time home buyers.
I'm surprised it's that low. I would actually think it would be higher.
This is from 2023, so it could be higher in 2025.
Yeah, for sure. For sure. Wow.
I just had a comment. So my daughter, she's 25. Are you seeing young people be more, so she says to me, for example, Ralph and I are having our monthly financial meeting. So they're really into, now I don't know if it's because we're financial planners, but they're very open about finances, which prior generations were not.
I've definitely seen it with because I deal with a lot of the parents, right? And then they introduce me to their kids and then I help them, but I'm dealing with the parents a fair amount. But in the conversations, it has come up that the kids today, I call them kids, they're young adults, but they 100% are way more open. But in general, I mean, even look at the way we talk about menopause on social media. I mean, it's true, like all these different things. The internet and Instagram and all these different platforms have made us so much more open, and there's so much information out there, and people feel like they can say whatever they want to, like sometimes a little bit too much of it. It's a
Too
bit
much
too much.
oversharing.
TMI, you know? But people are very comfortable with it. So I'm not surprised that that generation is like that. And I actually do have a niece and her boyfriend, and I've seen their like spreadsheets for travel. It's
Exactly.
incredible.
Yeah.
I'm
Yeah.
like, can you teach me how to do that? You know, I just know what's in the account and I just do it in my head and glance, but they've got pies, graphs, all sorts of stuff. It's actually amazing and very responsible.
And I think they're aware of the divorce rate. It's because, again, of social media and just access to information. And so I think they're just generally more savvy about that type of stuff than some of the previous generations were.
So just before we close off, because I know that we're almost at our time, is there any tips or any information that you'd like to impart us with to say this, you know, in light of these kind of things, what could we be telling our clients?
From my end, from the legal perspective, I would say your client should get legal advice on what they're planning to do. And if you have a client who is getting married or looking at living with somebody, I recommend that they get a marriage contract or a cohabitation agreement, and then everything can be set out and there won't be any surprises or problems down the road.
And I definitely agree, obviously, with Leanne in what she just said. But on top of that, the other thing is maybe investigate a little bit more. Feel free to reach out to me. I do have some mortgage brokers that are a little more informed on the newer rules with these allowances once they are divorced or separated. But when you are guiding your clients who are helping children with, you know, they're in new relationships or helping to buy a property, I would definitely say a little tough love, like they might not want to hear it. I'm going to actually close with a really cute story. My husband and I were in Jamaica and it was a pouring rain day, and we met this couple who came to this resort all the time, and their son was getting married and they were really excited, and we didn't say anything about what we did, and they were just telling us about them buying this new house. And you know, it was really hard for Steve and I to keep our mouths shut because all we're thinking is post-nup, I mean prenup, and they're American, so I definitely could say prenup. And finally, we kept looking at each other, and we're like, we're never going to see them again. They should be like told. And so we said something, and at first they had their back up like you wouldn't believe. Oh my God, they've been together forever, blah 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 blah. Anyways, within about 20 minutes of talking to us, i.e., talking to professionals like yourselves, you can change someone's mind. Like we got in their head big time. And I think being honest in any profession is the way to build a relationship and to not have to be knocking on people's doors, and, you know, keep your referrals up by being honest, even though it might be information they don't want to hear.
Oh, that's a great piece of advice. Thank you very much. Well, thanks to you both, Samantha and Leanne. And I think you've given us lots to think about. Yeah, it's great.
And if anybody has any questions, like I said, for either one of us, we're always happy to answer on a one-to-one basis.
Yeah, we can provide our emails even in the chat if anyone wants to email us.
Yeah, and what I'll do is I'll forward that on to everybody too.
Thank you.
Have a great day, everyone.
Thanks, everybody.
Thanks very
Bye.
much.